Hello, everyone. Welcome to Court with Krissy. All right. I've got two updates. One which was a complete surprise. AI plus DUI is back. And was it fact or fiction that he was not out joyriding? And then the 10-9 update I was anticipating. The traveling nurse gets sentenced by the visiting judge. I have a feeling the judge also loves those redheads. I hope you like it. Court with Krissy is now in session.
We will go on the record in the matters 24 CT 88, 24 CT 91, State of Wisconsin versus Benjamin Lamprecht.
Kind of a math question. I just want to know if it's fictional or a fact.
The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Lamprecht appears in person without counsel. We're set here today in this matter for initial appearances. Mr. Lamprecht, did you receive copies of those criminal complaints?
Yes.
Did you read them thoroughly?
Not really.
Can you read and can you write?
Yes.
And it alleges that in 24 CT 88 that you operated a motor vehicle on July 31st, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law. You operated a motor vehicle on a highway during such revocation period or thereafter, and that revocation was a result of an OWI or similar related offense. Contrary to Wisconsin law, a misdemeanor. Upon conviction, you face a fine of not more than $2,500 or imprisonment of not more than 1 year in the county jail or both. Do you understand that count and that maximum penalty?
Yes.
In 24 CT 91, it alleges two criminal counts. Count one, operating a motor vehicle while revoked. It alleges on August 12th, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you operated a motor vehicle on a highway during such revocation period or thereafter, and the revocation was a result of an OWI or similar related offense. Contrary to Wisconsin law, a misdemeanor. Upon conviction, you face a fine of not more than $2,500 or imprisonment of not more than 1 year in the county jail or both. Do you understand that count and that maximum penalty?
Yes.
Count two, failure to install ignition interlock device. It alleges the same date, the same time, the same place that you did fail to have an ignition interlock device installed as ordered by the court, a misdemeanor. Upon conviction, you face a fine of not less than $150, but no more than $600, or imprisonment of not more than 6 months, or both for the first offense. Do you understand that count and that maximum penalty?
Yes.
Not guilty pleas will be entered on your behalf. You are entitled to jury trials, and you would be entitled to speedy trials should you request one. Are you still on road?
Yes, I am.
And does your phone number,
Yes, it does.
may we send you text message notifications of upcoming hearing dates?
Yes.
Where are you in the process of getting your driver's license?
All I have left to do is like another couple of weeks of going to the counseling or whatever.
All right, and so you should be able to get your license by then? So you just need a few months to do so?
No, like a few weeks.
Few weeks? So, Mr. Schmidt,
Maybe a month. I don't know. Something like that.
what would an offer be?
Shouldn't you be revoked for another year or so?
Well, he could get his occupational probably.
That's why I was gonna offer, if he gets an occupational, I'd do an ordinance for costs for OER.
All right, so if you're able to get your occupational, then what the state would do would ask the court to amend from crimes down to an ordinance to a ticket for costs only, okay? So I'm gonna give you some time to work on your driver's license. December 6th at 1 p.m. December 6th at 1 p.m. You're gonna come back to court and you're gonna update me on where you are in the process, okay?
Okay.
All right, come and get your notice and you're free to go.
I wasn't joyriding enough. I was just trying to get to work.
I probably should say you probably don't want to make any statements on the record because it can be used against you. I
Okay.
do know that you want to get this matter resolved and you would like to work through it and
All right. I'll shut my mouth.
okay, so come and get the notice and then you are free to go. Thank you. Tanya Wolf, you can come on up.
Chelsea Blankenship. So Mr. Johnson's your attorney, right? We'll have to wait while he comes back in the courtroom. So if you could go ahead and have a seat. Johnson, you ready with Miss Blankenship, right?
I am. Can we do a procedural matter first?
Sure.
May I call with Mr. Kane? Your Honor, I had a pretrial this morning with Brian Ager. Thank you. Now we have Ms. Blankenship.
Okay. Miss Blankenship.
Doing good. I gotta make sure this is for me. No, this is for me. I don't know if this is for you.
Need to mute them or what?
I'm not sure who they are bringing.
I believe we have,
Another individual for sentencing for,
no, actually, we don't need, we're finished with the Department of Corrections, so I don't think
okay, well, they've
that up at all.
disappeared apparently, so. All right, Mr. Johnson, you're representing Miss Blankenship, and you've had a chance to look over the pre-sentence materials.
We did not receive a pre-sentence report. It wasn't clear whether or not a warrant issued or not.
You want to
Yes, if I
take a look at ours? Yeah. Not great.
ready for us, Your Honor?
Oh, yes,
May I approach?
you bet. Thanks. Okay, so we did have a pre-sentence report prepared, and you've now had a chance to look it over.
We have, Your Honor. I think the only correction would be it doesn't have information on who she lives with, and she does live with her parents.
Okay. So, Ms. Blankenship, if I were to tell you that you would be going to jail today, would you tell me that you've got better things to do?
No, sir.
What's your problem with complying with some simple bond conditions?
Sir, I didn't even mean to comply. I was actually at work about to clock in when it had told me I violated. I went to my police department as soon as I violated to have them give me a breathalyzer. They refused to do one because it is Michigan and they did not want to have any issues or have to be called for anything. So they refused to give me a breathalyzer. I contacted the bond officer for 3 days, hoping to get a hold of her so that way I could come somewhere in Michigan to do blood work to prove that I did not violate. And then she finally calls me back after 3 or 4 days, and it was to just tell me that I had a warrant. It was not, she was not trying to hear me. I did not violate, and it's not that I wanted to not comply. It's just I felt like there was no help. I was meeting a road that had no ending. I don't know.
Your Honor, if I may expound just a bit.
But just, excuse me, you're still living in Indiana.
Yes, sir.
Okay.
And I was trying to come up here to do blood work to prove that I did not violate.
Well, just to review this though, you were ordered on August 6th to submit the daily breath testing. Apparently you got an in-home unit through Smart Start shortly thereafter. And a couple of weeks later, on August 25, there was a positive blow. And then a skipped retest. And apparently that was resolved. You pled guilty to that bond violation.
That is correct.
And then they increased the breath test to twice a day. They'll fix that, right? And so then September 7, positive breath test again, followed by a warrant, and then you were locked out of your Smart Start.
You're just on that on the 7th violation, she flew at 6:02 as zeros, but there was an issue with her face. She 15 or so seconds later, where it was the 0.007 and then 0.006. So very, very low numbers. I talked to her and she said, go to a police station, but at that time, those numbers were presumably zero. 10 o'clock before, got up, went to work at 6 o'clock that day. So she's not sure what happened there, and she just has not been through this process before. I think she got very frustrated that there wasn't an immediate answer on what was going on or how to fix this. And obviously she didn't respond appropriately. She kind of gave up, unfortunately. So what I would also point out, Your Honor, the original charge was operating while intoxicated. It was reduced to an impaired. It was a 0.08 that she did blow. It was very, very low. She has very minimal criminal history. She's a young woman with a whole life after. She obviously needs to take a look in the mirror and figure out whether or not alcohol has any place in her life, because it may very well be that it's certainly not worth it. And obviously, if she gets another, she's losing her license for an extended period of time. But
this is her third substance abuse issue, and she's 24.
I
so that's a large thing. That's not a minor
Your Honor,
issue.
the possession of the alcohol container, that was just because I was the oldest person in the car. Unfortunately, I was sick with COVID when I got pulled over. I just unfortunately got stuck with that charge, but I was not under the influence of anything when I received that charge.
So are you right now, what I would be doing if I were you is thinking about how you're going to explain away the next charge. What excuse are you going to have for the cop or the judge next month or next year? I think you're going to be running out of excuses. That's what I think. Well, certainly probation's not in the cards, and the numbers are too low to get excited enough to require a jail term. I'm going to follow the recommendations, which are 200 fine, 100 costs, 75 to crime victims, 50 to the state, repay the cost of counsel in the amount of $275. Credit for time served.
Thank you.
All right, you bet.